Patriots, we have a critical update in the suppressor case that could change Second Amendment law forever. And what just happened is absolutely shocking. The Fifth Circuit just made a stunning decision that has left gun rights advocates furious. We're talking about a case where a man faces prison time while the Supreme Court is about to review whether his conviction is even constitutional. This is U.S. v. Peterson, the suppressor case that's become ground zero in the fight over NFA regulations. And folks, the Fifth Circuit just threw Mr. Peterson under the bus, despite the Trump Doge agreeing he should remain free during his Supreme Court appeal. Before we expose this entire situation, hit that subscribe button and ring the bell. We're bringing you Second Amendment news that mainstream media won't cover. Let's break down this explosive development. The case let me take you back to 2022 when this case started, because understanding what happened is crucial to understanding why this Fifth Circuit decision is so outrageous. In 2022, a massive law enforcement operation descended on Mr. Peterson's home in Louisiana. We're not talking about a routine visit. This was a federal task force with TF agents and approximately 50 law enforcement officers executing search warrants. Mr. Peterson operated a home-based federal firearms license business. During this raid, authorities claimed various issues, some Form 4473 paperwork problems, allegations about firearms traced to crime scenes, standard FFL compliance concerns. But here's what's important. Out of everything they investigated, the charge that's causing this entire constitutional battle involves one item: a single solvent trap found in Mr. Peterson's bedroom safe that wasn't registered under the National Firearms Act as a suppressor. That's right. One unregistered suppressor component has become the test case that could reshape NFA law. Mr. Peterson didn't accept this quietly. He filed a motion to dismiss the charges, arguing that the NFA's suppressor restrictions violate the Second Amendment. The district court denied his motion, so he appealed to the Fifth Circuit Court of Appeals. The first Fifth Circuit the Fifth Circuit's initial ruling was terrible for gun rights. A three-judge panel reviewed the case under the Biden administration and ruled that suppressors are not protected arms under the Second Amendment. They claim suppressors aren't a necessary component of a firearm required to make it useful or functional. This was insane logic. By that standard, almost no accessory would be protected. Scopes? Not necessary. Slings? Not necessary. This was setting a dangerous precedent. Mr. Peterson's legal team immediately began preparing for en banc review when the entire Fifth Circuit, not just three judges, would reconsider the case, but then something unprecedented happened that changed everything. The Trump Doge when the Trump administration took control, the Department of Justice did something shocking. They reversed the government's position. The Trump DOJ filed papers admitting that suppressors are protected arms under the Second Amendment. This was a massive shift. The federal government itself was now acknowledging constitutional protection for suppressors. This meant the Fifth Circuit had to reconsider the case with this new framework. Mr. Peterson's team withdrew their en banc petition thinking, with the government admitting suppressors are protected, surely we'll win now. But what happened next was even more shocking than the original ruling. The Fifth Circuit's shall issue permit the three-judge panel came back with a new ruling that's arguably worse than the first one. They said, okay, fine, suppressors are protected arms. But the NFA restrictions are still constitutional because the NFA operates as a shall issue permit system. Let me explain why this is absolutely catastrophic for gun rights. The judges twisted language from Justice Kavanaugh's concurrence in the Brune decision about concealed carry permits. Kavanaugh mentioned that objective licensing schemes, background checks, fingerprinting, these might be permissible for concealed carry. But the Fifth Circuit took that narrow statement about CCW permits and applied it to justify the entire NFA regulatory framework. They're saying, if we can require permits for carrying guns, we can require registration, $200 tax stamps, months of waiting, and a TF approval for suppressors. Do you see how dangerous this is? The Fifth Circuit just created a blueprint for gutting the Second Amendment through licensing schemes. Under this logic, the government could require permits, registration, fees, and waiting periods for standard capacity, AGAZINES AR-15s and other rifles and ammunition. Purchases NY firearm accessory, all they have to do is call it a shall issue permit and claim it uses objective criteria. This ruling essentially says constitutional rights can be transformed into government-controlled privileges as long as you follow some bureaucratic process. Peterson seeks Supreme Court review after this devastating ruling. Mr. Peterson had one option left: the United States Supreme Court. His legal team informed the Fifth Circuit, "We're taking this to SCOTUS. We need you to stay the mandate so Mr. Peterson doesn't have to report to prison while the Supreme Court considers our petition." Now, here's what's really important. This motion was unopposed. That means the Trump DOJ, the opposing party in the case, agreed to the stay. They said, "Yeah, we're fine with Peterson staying out on bond while the Supreme Court reviews this." You would think this would be automatic, right? Both parties agree Supreme Court review is pending, constitutional questions are at stake, and a man's freedom hangs in the balance. The Fifth Circuit should have granted the stay immediately. The Fifth Circuit's cruel denial, but they didn't. The Fifth Circuit issued a brief order denying Mr. Peterson's unopposed motion to stay the mandate. No explanation. No reasoning. Just denied. Think about what this means. Mr. Peterson now faced going to federal prison, while the Supreme Court, the highest court in the land, was preparing to review whether his conviction is even constitutional. His attorneys laid out the stakes clearly. Peterson will suffer irreparable harm if required to report to prison during the pendency of his petition. If imprisoned before the Supreme Court rules, he could be deprived of his liberty for a conviction that SCOTUS would ultimately vacate. The Fifth Circuit knew this. They were told this. The Trump DOJ agreed with this. And they still denied the stay. This is the kind of judicial cruelty that makes you question whether courts truly care about justice. The district court saves the DAY, but here's where the story takes a positive turn. After the Fifth Circuit denied the stay, Mr. Peterson's legal team went back to the district court, the original trial court, and asked for the same relief. And guess what? The district court granted it. The district court issued an order stating, "George Peterson shall remain on bond under the same conditions and with the same stipulations as originally set by the court pending resolution of his petition for certiorari to the United States Supreme Court." Finally, some judicial common sense and humanity. The district court recognized what the Fifth Circuit apparently couldn't, that a man shouldn't be imprisoned while the Supreme Court is actively considering whether his conviction violates the Constitution. So Mr. Peterson gets to remain free during his Supreme Court appeal, no thanks to the Fifth Circuit. Why this ruling is Talk about why the Fifth Circuit's shall issue permit reasoning is so dangerous for every gun owner in America. First, the precedent problem. If this reasoning stands, it creates a roadmap for destroying the Second Amendment through licensing schemes. Any restriction can be justified as long as it's framed as an objective permit system. Second, the NFA expansion. The NFA isn't just a simple permit. It involves federal registration of your personal property, $200 tax per item, hundreds of dollars, months of waiting for a TF approval government, database of what you own, potential denial without clear, recourse criminal penalties for paperwork errors if that passes constitutional, scrutiny as a shall issue permit, then virtually a NY gun. Regulation can be justified. Third, the slippery slope. Once courts accept that constitutional rights can be heavily regulated through permit schemes, where does it stop? Could the government require permits for free speech with background checks and fees? Religious exercise with registration requirements? Assembly and protest with waiting periods? This Fifth Circuit logic could be applied to an NY constitutional right. Fourth, the circuit split. Other circuits might disagree with the Fifth Circuit's reasoning, creating a circuit split that forces the Supreme Court to step in and resolve the conflict. What happens at the Supreme Court? Now this case is heading to the Supreme Court. Here's what we're watching for. Step 1. Mr. Peterson's legal team will file a petition for certiorari, the formal request for SCOTUS to review the case. Step 2. The Supreme Court will decide whether to grant or deny SUT. They only take about 1 to 2% of cases, so this is a high bar. Step 3. If they grant SUT, we'll see full briefing, oral arguments, and eventually a decision, probably in 2026. The big question: will the Supreme Court take this case? Arguments for taking the case. Circuit Court applied. Bruin incorrectly twisted CCW permit dicta to justify. NFA created dangerous precedent for all gun rights. Trump DOJ already conceded suppressors are protected arms. Perfect vehicle for clarifying NFA constitutionality. Arguments against taking the case. Court might not want to tackle NFA yet. Procedurally complex with the DOJ reversal. Might prefer to wait for a cleaner case. My prediction? The Supreme Court should take this case. The Fifth Circuit's reasoning is so flawed and so dangerous that it demands correction. The Trump DOJ's position probability is something really interesting to watch. What will the Trump DOJ argue when they respond to Peterson's Supreme Court petition? The Trump DOJ has been very firm in defending the NFA. They've defended NFA restrictions in multiple cases, even while claiming to be pro-Second Amendment. They've already conceded that suppressors are protected arms. But they're still arguing the NFA can restrict them through the shall-issue permit framework. This creates a strange position for a supposedly pro-gun administration. Yes, suppressors are constitutional protected, but yes, we can heavily regulate them anyway. And yes, we'll oppose Supreme Court review. Gun rights advocates are frustrated. They're asking, if the Trump administration really supports gun rights, why are they defending a 1934 law that turns constitutional rights into expensive bureaucratic privileges? The answer might be political calculation. They don't want to be blamed if the Supreme Court strikes down the NFA and something bad happens with an unregistered suppressor or SBR. But that kind of cowardice on constitutional principles is exactly how we lose rights. What gun owners need to know if you are a gun owner. Here's what you need to understand about this case. First, the stakes are enormous. This case could determine whether the NFA's regulatory framework survives constitutional scrutiny or whether major portions get struck down. Second, the shall-issue permit logic is dangerous. If it becomes established precedent, states and the federal government will use it to justify all kinds of gun control. Third, support matters. Organizations like Gun Owners of America, Firearms Policy Coalition, and Second Amendment Foundation need resources to fight these battles at the Supreme Court level. Fourth, this will take time. Even if SCOTUS grants SUT, we won't see a decision until 2026 at the earliest. Constitutional litigation is a marathon, not a sprint. Fifth, stay compliant. Until courts rule differently, NFA items still require proper registration and tax stamps. Don't become a test case yourself. Sixth, pay attention to how courts rule, not just whether they rule in our favor. The reasoning matters as much as the outcome. CLOS on jailright patriots, that's the complete breakdown of this critical suppressor case heading to the Supreme Court. Let me summarize the key points. Fifth Circuit ruled NFA is constitutional as a shall-issue permit. Trump DOJ conceded suppressors are protected but still defends NFA. Fifth Circuit denied stay even though Trump DOJ didn't oppose it. District Court stepped in and allowed Peterson to remain on bond. Case now heading to Supreme Court for possible review. This could reshape NFA law and Second Amendment jurisprudence. The Fifth Circuit created a dangerous precedent that threatens all gun rights. The Supreme Court needs to step in and correct this twisted interpretation of Bruin. If you found this breakdown valuable, smash that like button. Share this with every gun owner you know. They need to understand what's at stake. Subscribe and hit the notification bell for updates as this case develops. Comment below. Do you think the Supreme Court will take this case? Should the NFA's suppressor restrictions be struck down as unconstitutional? I want to hear your thoughts. Remember, the price of liberty is eternal vigilance. We cannot let courts chip away at our constitutional rights through creative interpretations and bureaucratic schemes.